Manager here at Clinks. We have got a lot of people joining us, but we'll obviously just start a bit of an introduction. So this session will be recorded. The idea of it, that is, we're going to share it. We're going to put it out there for anyone who wasn't able to make it due to the summer holidays. However, we're not going to record the question and answer session. So this is so that any questions that we do gather today, we'll pull together into a document and we will share it separately. So we'll make sure all answers are shared, but it means that no one question will be attributed to any one person or organisation. So we're going to go through as a team different elements of the Sentencing Act. We'll have a comfort break halfway through. And if as we go, you'll see in the team there is a Q&A function. Please put any questions in the Q&A function so they're not lost in the chat, and then we'll save them all to the end, and we've got about 25 minutes or so for the Q&A. So we would really encourage you to put those in there as you go through. If we run out of time or we can't answer any questions that we need to go back to HMPPS for, we'll take them away, and then, like I say, we'll get a written response out to the sector, as well as the recording of this seminar. So a bit of an agenda for today. We'll try to stick to timings where possible, but like I said, we will finish by 11:30. And we're going to just go through the context, the different phases of implementation, have a break, talk about kind of what you have been telling us and how we're using this to influence, and then in the Q&A, whether that's questions, answers, comments, any thoughts you'd like to share with us, that's the kind of chance we'll have for that. So for anyone who doesn't know what Clinks does, because we have got a lot of faces on the call today, which is brilliant. We are the infrastructure organisation for the voluntary sector in criminal justice. We are basically there to advocate and support the voluntary sector. We're split into 3 functions. So we have our business development team, which is kind of our internal finance, governance, HR. We have our national influencing team, which colleagues are on the call today that you'll meet, which focuses on the influencing of national policy, our communications work, and our thematic networks. And our thematic networks are women, race, health, arts, and families. And then we have our area engagement team, which I'm part of, and a couple of my colleagues are here today, where we provide support to the sector in each of the English regions and across Wales. We spend time understanding the sector's issues, challenges. We work really closely with HMPPS to improve collaborations. We run training and events, and obviously we work really closely with the national influencing team to make sure we kind of feed in whatever those challenges are coming into the policy, national policy scape. What I would say is if your organisation is not a member already, then we'd really encourage you to join, because membership's our strength. Your voice is how we then advocate on your behalf and what we need. So that kind of membership, we'd really welcome you. So we've got the link on the slides. We'll share the slides afterwards. But if anyone's got any questions or comments and need any support, we've popped the support at and the policy at mailbox, just because of the time of year, people are on leave, so you might get a bit of a delay if you reach out to one individual. So if you just reach out to anyone, do it through those mailboxes. And I'm going to hand over to Sam, who's going to talk about the kind of the context of the Act.
Thanks, Natalie. Hi everyone, lovely to see you all, even if it's on a small screen. I think, and someone will correct me, this is probably our best attended event, and I think that ties in with the fact that this is such a significant piece of legislation, but also the fact that it's so complex, and also a bit of a moving feast, which we will cover throughout this session. I was just going to kick off to talk about context before handing over to colleagues who are going to run through the key measures. And then, as Natalie said, please get your questions in. We will endeavour to do our best to answer them today, but we'll definitely be able to come back to you if there's anything that needs further clarification. So looking at the context of the Act, Most people here will be aware that we have a prison system that has been overcrowded for a number of years. And the then Starmer government decided to commission the Independent Sentencing Review in 2024 to look at how we can develop long-lasting solutions that would tackle overcrowding in our prisons. Starmer commissioned former Justice Secretary David Gauke to lead that review. And the idea was to look at how they could create more headroom in the prison estate. Well, the work was done throughout 2024, and it culminated in the publication of their final report in 2025. That was previewed by an interim findings, which laid the groundwork for what we expected to be measures that would rebalance our sentencing regime away from one that has focused excessively on sending more people to prison for longer sentences towards the development of more community-based approaches. And as you look, as we go through the key measures, you will see that is certainly the ambition within the Act. As we will also talk about, some of these measures have led to, shall we call it, a public outcry around who is and isn't eligible for, in particular, what's known as the earned progression model. Following the publication of the review in 2025, the government accepted the vast majority of the recommendations within the review. The key recommendation that wasn't taken forward was about incorporating people serving extended determinant sentences into the progression model. So that was rejected by the government. The Sentencing Act went through its variety of parliamentary stages, and it became law in January of this year. The implementation of its core measures will take on two phases. Phase one began in March of this year, and we have a number of slides, as you will see, that looks at those key measures. And then phase two beginning from around September, so imminently. And again, we will cover those in a little more detail a bit later. These longer lasting solutions, and I say solutions in inverted commas because it remains to be seen the impact, follows on from previous emergency measures that many of you would have been working with, such as the SDS 40 scheme and the ECSL scheme. The important thing to note is that combined, the measures in this Act is not a silver bullet to the many of the issues that you grapple with every single day. For those nerds that have looked at the impact assessment that accompanied the bill, you will see that were all the measures in this Act to be implemented, the prison population would still grow by 2,000 by 2029. So it is not the silver bullet, but it is essential in order to create some more headroom for the estate. The final thing I wanted to say was, following my comment about the public outcry, the Prime Minister has tasked the new Justice Secretary, Alex Norris, with presenting a plan to Parliament when Parliament returns at the beginning of September to create more headroom in the prison estate. This follows, as I said, the public outcry around the earned progression model and certain people that would have been eligible to be released earlier on in their sentence. The plan is reviewing three specific areas. The first is reviewing IPP sentences, which I know a lot of you would have spoken about publicly. The second will look at speeding up the deportation of what are known as foreign national offenders. And the third is looking at how can we utilise the women's estate, essentially to free up more room for men in the prison estate. Just wanted to finish by saying that within the review itself, which I'm sure all of you already know, one of the core recommendations was around the role and the value of the voluntary sector, and it was about funding the voluntary sector. We know that funding hasn't necessarily trickled down to the sector, and I'm sure lots of you will be asking about the measures to increase funding for probation and what that means for the voluntary sector. Recently, the language has changed to say the 700 million is for both probation and community services, and that's something that we'll be focusing our attentions on as we look to influence the government in the coming weeks and months. So that is a kind of whistle-stop tour of the context, and I'm now going to hand over, I think, back to Natalie.
Yep, that's right, Sam. Thank you. I'm just going to talk you through phase one of, as Sam said, came in March, and then I'll pass over to Bryn, who'll talk about the phase two. So one of the implementation timeline phases is the presumption to suspend custodial sentences of 12 months or less. So the courts have a range of robust powers for when a sentence is suspended. A suspended sentence can include one or more of the 14 requirements available for community orders, such as electronic monitoring, community payback. The courts have the flexibility to choose and balance requirements in line with the statutory purposes of sentencing. The Independent Sentence Review recommended that the government legislate to ensure short custodial sentences of 12 months or less are only used in exceptional circumstances. While short custodial sentences may be useful in some circumstances, they often do not provide meaningful rehabilitation, have high financial and personal costs. The analysis shows that suspended sentence orders and community orders are much more effective in reducing reoffending when compared to short sentences of immediate custody. So the Act introduced a statutory presumption that courts suspend custodial sentences of 12 months or less unless in exceptional circumstances. And for example, cases involving breaches of court orders, re-sentence situations, people who have been subject to a supervision order, those at significant risk of physical or psychological harm, particularly in domestic abuse contexts. The Independent Sentence Review did not recommend a complete abolition of short custodial sentences and noted they will continue to be appropriate in some circumstances. Clinks is happy towards the move of significantly limiting short sentences, but I think we may have missed an opportunity given the decision to pursue a presumption towards suspension as opposed to outright abolition with exemptions. A suspended sentence for all intents and purposes is ultimately a custodial one, limiting judicial autonomy, posing issues for future disclosure and risks up-tariffing as well as escalation towards more serious sentences. The extension of the period of time for which a custodial sentence can be suspended has also changed. So the scope of suspended sentence orders has been expanded. Previously, they could only be imposed for sentences of imprisonment of 2 years or less. This is now increased to 3 years. Courts can also suspend a sentence for up to 3 years rather than the previous maximum of 2. So this means that the courts now have the power to sentence a person to 3 years imprisonment, suspended for 3 years. The aim of this approach is to incentivise people to behave well and comply with their orders and any requirements imposed to avoid serving their sentence in prison. Clinks thinks that given sentences to be the power to be able to suspend sentences of up to 3 years as opposed to 2 is a positive one. However, individuals under community supervision will potentially require support for an additional year, intensifying demand on voluntary sector organisations, those that provide housing, health, mental health, rehabilitation services. Without increased funding and capacity building, as was recommended in the Independent Sentence Review, this could overstretch services and reduce effectiveness and shift the crisis in prisons to a crisis in probation and the community. They've also extended the maximum period that a sentence can be deferred from 6 to 12 months. So the Act increases the maximum sentence deferral period from 6 to 12 months. A deferment order enables the court to delay passing a sentence. The court may impose requirements during the period of deferment, such as attendance at rehabilitation programmes, or deferment orders enable sentences to consider the person's conduct after conviction and any change in their circumstances when making decision making. This is intended to encourage greater use of community sentencing. Clinks thinks that this should help to less punitive and more rehabilitative sentences decisions at the end of the deferment period, especially for people facing more complex needs. There's been an amendment to the Bail Act which came into power at March 26. So the no real prospect test has been amended to a no real prospect of immediate custody test, so that fewer exceptions to bail will apply. The test will apply where the court considers A, that there's no real prospect for the defendant to be sentenced to an immediate custodial sentence, and B, to defendants who have been convicted but are awaiting sentence. The court can impose the use of electronic monitoring to people who would otherwise not be granted bail. This is welcome given the fact that 20% of prison population is on remand. Around 2/3 are awaiting trial and the rest are awaiting sentencing. Remand prisoners typically have fewer privileges than sentenced prisoners, are less likely to be in stable accommodation within the prison, have more limited access to education, work and rehabilitative programmes. They cannot be compelled to engage with sentence planning because they've not been sentenced. Family visits are often more limited, and the uncertainty of their situation, not knowing when their trial will be, what the outcome will be, or whether they will be convicted, adds a layer of psychological stress that's particularly acute. You may have heard of the fixed term recall, or FTR 56, which was introduced. So the independent sentence review of the sentence framework included looking at the recall population, which has more than doubled over the last 7-year period from 2018 to 2025. This has gone from around 6,000 people to around 13,600. Recall operates within a wider probation and prison system and is an important response to non-compliance and escalating risk. The Independent Sentence Review and the Act maintain recall as a public protection measure. The Act removes existing short-term recalls of 14 or 28 days and replaces them with a longer 56-day recall. This change aims to give probation more time to implement risk management plans, set appropriate licence conditions, and to ensure a safe release into the community. It's only applicable to those sentenced to 4 years or less and excludes certain offences such as MAPA, terrorism-related offences, threat to national security, or recall due to being charged with a further offence. Clinks is concerned with the provision to extend the fixed-term recall period to 56 days, as this fails to address the underlying causes behind the high rate of recall. Instead of addressing these causes in the community, thereby reducing the likelihood of a person being recalled to prison, extending fixed-term recalls risks simply increasing the revolving door cohort of people who are consistently recalled and then re-released. Income reduction orders are a new type of ancillary order which judges may impose alongside a suspended sentence order for people who earn above a minimum income threshold, or where it appears to the court that they will do so during the operational period of their suspended sentence. The income reduction order requires people to pay a percentage of up to 20% of their excess monthly income above a threshold for up to the duration of their sentence. As a result of other measures in the Act, some people will spend all or greater proportion of their sentence in the community. Orders such as the IRO are seen as an additional punitive element that the court can choose to impose as part of an offender's sentence to ensure that the sentence is proportionate to the offence or the offences in question. A community sentence progression scheme has been developed. It's to incentivise people on community sentences to engage early with probation, their court order requirements or their sentence plan. This scheme provides for termination of a community order or the supervision period of a suspended sentence order if the person completes both their court-ordered requirements and all other objectives of their sentence plan. This is intended to encourage early engagement and compliance with the order and to focus practitioner time and interventions on people who commit more serious crimes or have more complex needs. By focusing on the needs of the person who have committed the offence and the community, the scheme aims to reduce reoffending and protect public safety. Clinks thinks whilst this progression scheme is a positive one, it relies on sentencers having the confidence and understanding of the range of options available to them in terms of potential requirements, and also that any services linked to these requirements are properly resourced. I'm going to just pass you over to Bryn. Before I do that, I've noticed there's a couple of hands up. If I can just ask that you put any questions in the Q&A box, so then we can pick them up during the Q&A section at the end so we don't lose them. Thank you.
Thanks, Natalie. So I'm just going to talk us through the next couple of slides, which are around phase 2 of the Sentencing Act. And we're going to start with the progression model. And that's the element of the Sentencing Act that has been covered in the news a lot recently and has created quite a lot of political discourse, as Sam was alluding to earlier. And that was the element of the Sentencing Act that had been paused and a review was undertaken. So again, that's what was mentioned earlier. However, the key elements remain within the progression model, though the excluded offences have been expanded, and we'll go through those in the next slide. But those serving standard determinant sentences, or SDS, with automatic release of 2/3 will now be released at the halfway point of their custodial sentence, and those serving standard determinant sentences with an automatic release of 40 or 50% will now be released after serving 1/3 of their sentence in custody. She said, so the Act introduced this progression model for everyone who's serving a standard determinate sentence, and there will be a 3-stage structure within that. The first third of the sentence will be spent in custody. The second third will have intensive supervision in the community with restrictions, and the final third will remain on licence with no active supervision in most cases. But I think it's important to state that that you're still serving your whole sentence. It's just you're serving that sentence within different settings. So within custody, being supervised, and then on license, with always the possibility of being recalled around that as well. And that's something that maybe isn't always explicitly said in the media when we have dialogue around what the progression model actually is. So if we just move on, just talking more about the progression model. So those excluded offences now include rape, child sex offences, child pornography and grooming, and including these offence categories, over 18,000 people will now be ineligible for the progression model, as well as those who are on life and extended determinate sentences, EDSs. So there'll be 10 tranches of release, which will be commencing on the 1st of October. Those were due to commence on the 1st of September, so we've shifted the timelines by a month. And we're now expecting around 5,000 people to be released, and there's also the potential for more offences to be excluded. And we understand that there's around 1,000 people who were due to be released under the 1st of September who now aren't. They fall under those excluded offences. We're expecting to hear what the numbers for tranches 1 and 2 of the progression model to be announced by the 21st of August. So that hopefully will give service providers some time to start planning, and also those people as well who are expecting to be released, give them some time to understand when they're going to be released. The government have announced a whole package of support for victims, and once we send out the slide, you can follow that link to look at those the support that the government are putting in place for victims. There's going to be an allocation of £10 million for funding to fund extra local frontline services, offering that trauma focused support, and of course Clinks supports that wholeheartedly. Okay, and then further reforms. So under phase 2, there are these further reforms. So the maximum time added to a custodial sentence following adjudication has been increased from 42 days to 84 days. And alongside the progression model, there'll be more stringent requirements post-release. So there'll be a further expansion of electronic monitoring for the majority of people serving standard determinate sentences, and that includes a pilot in 6 prisons fitting people with the EMs, the electronic monitoring, before they leave. So around the electronic monitoring expansion, Clinks thinks that we have concern around the safety of women and vulnerable people when they're tagged. Women may end up being confined to an area that they're not safe due to factors such as having partners who have previously engaged in domestic abuse, knowing their location, as well as potentially leaving them vulnerable to drug dealers as well. well. So we do have some concerns around the electronic tagging and monitoring. From the 2nd of September 2026, there will be new community requirements, which include driving prohibitions, restriction zones and inclusion zones, and drinking and restrictions around drinking establishment bans. There are a number of concerns with this. We have a number of concerns with this. Most restrictions, such as in pubs and football stadiums, do not necessarily reduce reoffending or help with rehabilitation, and we do believe that they are unworkable. And then in the case of restriction zones, because we know that women can simultaneously offend and also be a victim of offending, there's that danger of restricting women and vulnerable people to spaces where they'll be unsafe. So again, a little bit like the concerns that we have around the electronic monitoring. Also then, the Rehabilitation Action Requirement, or RARS, will be replaced with the probation requirement. And again, we're concerned around the ineffectiveness of RARS, and that's been highlighted by the Ministry of Justice, with evaluations attesting to their inconsistency, unclear objectives, and a lack of meaningful rehabilitative activity, with the RARS often becoming a catch-all administrative requirement rather than enabling the provision of effective support. And again, when we're looking at working with women, this new approach should be particularly beneficial, particularly for women, as this offers them a more flexible support models that they often require, whilst enabling women specialist providers to offer individually tailored support packages. We could just move on to the next slide. From the 5th of October, there will be a formal judicial finding of domestic abuse at the point of sentencing in criminal cases to more effectively identify domestic abuse perpetrators. And again, we think around this that we're broadly supportive of this. However, it should not be forgotten that women in contact with the justice system are often survivors of domestic abuse, and this experience of abuse, such as through coercive control, can often be directly linked to their subsequent criminalisation. So we need to have an understanding of that. And then from the 18th of January next year, 2027, the number of hours of work required by unpaid work requirement must specify a minimum of 40 hours and must not be more than 300 hours. The government are supporting all of this extra pressure that's going to be put on the probation service by a £700 million investment in the probation service by 2028-29, and a recruitment of 1,300 trainee probation officers. However, Clinks would like to see that more support goes to the community and voluntary sector, and for these reforms to fully work, we advocate for the community and voluntary sector to be properly funded to support all of these reforms. I feel that Clinks feels that obviously it's important for investment to happen into probation, but actually the community and voluntary sector should be seen as partners within this and can help probation with all of these reforms, and that if the sector is properly funded, that will actually alleviate pressure on probation and will aid rehabilitation and reduce reoffending. So we strongly want to put that across the government, that the sector needs to be properly funded for the Sentencing Act to fully work. I'm now going to hand over to my colleague Michelle. Michelle, over to you.
Thank you, Bryn. Good morning. My name is Michelle, and I am the Area Engagement and Partnership Coordinator at Clinks. So my role, I cover the area of London. I support the organisations working with the London membership and the members of Clinks that work in that area, as well as coordinating the voluntary sector coordination model at HMPPS. So just to give a bit of a context in terms of the prison itself, it's a Category C prison, capacity of about 600. It's a London-based prison within the cluster of with Thameside and Belmarsh. And the point of this kind of part of the webinar is to kind of discuss things that have worked on the ground. I know many of the organisations here work through the gate, and you're based in a prison and want to know what would work, what's worked best, and what would work going forward in terms of being able to assess the needs of the people in prison, and to work well with the prison to ensure they're smooth through the gate process upon release. So obviously we've gone through the Sentencing Act already. We've had previous national early release schemes implemented, such as the SDS-40, which was people being released at the 40% mark instead of the 50% mark, which was in 2024. And then we had the end of custody supervised license, which is the ECSL releases, when people were released at 18 days before their release date. And what we found doing those things, we found some aspect that worked really well. We would like to kind of incorporate going forward, things that you can kind of look at in terms of your organization and what would work best for you if you have that connection with the prison. So what we found that worked really well was the preparation within your team. So again, information on potential numbers and capacity. So obviously we know the number of people being released, 5,000 next 10 months, and that will be different across different prisons in different areas of England and Wales. Prisons will start getting an idea of the releases that we'll have coming up. So if you get an idea and have a discussion with the prison in terms of what are the numbers that we've got coming out of this prison, I think that will help in terms of within your teams being prepared to see how your capacity, how you can meet the changes in the capacity and the increase that you have to now adjust to with the appropriate resources. Then have a relationship and kind of gain, if you don't have one already, with the head of reducing reoffending or the offender management unit. So in terms of the third sector, voluntary sector working in prisons, majority of the time your head of reducing reoffending will be your main point of contact. So if you haven't got that contact already, I would suggest make that contact and find out who that person is, and make contact with the OMU. So the offender management unit will be the one holding the prison officer managers and the probation officers, and they will have the information in terms of who's being released, and that will also increase your chance of doing the multi-agency work and sharing information, finding out what's happening in terms of the case that you're working with, and ensuring there's that sharing of information, especially when people's release dates have been changed, and to ensure that resettlement planning has been done efficiently. A mailing list. So that's something that we found really, really useful. Obviously, I am the coordinator at the prison, so it kind of helped me being there to coordinate that, but it's not something that other organizations can't do within the prison. So if you could speak to the OMU to set up a mailing list where you can, once they find out the new releases that get released and how that when they get that notice period, hopefully within a few weeks or more, you can then be sent added on a mailing list. So when the information comes through, they will automatically mail you the list of people being released, the change of the dates. So then you have that information up to date as much as the OMU does. So you can do that work before that person comes out. A lot of organizations, we work, pre-release, for example, 3 to 4 months pre-release. And if that changes, third sector organizations cannot do their work if they're not aware of the change of dates. And that's how obviously that leads on to issues such as being recalled and reoffending upon release. Attendance at prison meetings, such as reoffending meetings. So different prisons will have different monthly meetings where you discuss things and come together with different departments. So I'd really suggest kind of attending those meetings. So at HMPPS, we have a reducing reoffending on a monthly basis where all departments, both voluntary sector, prison departments attend. And that's a great opportunity not to just meet other third sector organizations to share good practice and those kind of ideas, but also great to find out what's coming from a prison perspective and get all the up-to-date information that you need, especially with the Sentencing Act and those kind of changes that we've got. Access to NOMIS for pre-release support, updates and email communications from prison in regards to prison-specific changes. So I'm not sure if all organizations have access to NOMIS. I know a lot of them do if you work in the prison, but if you're contracted outside of prison, if you're through the gate, you might not have that contact with NOMIS and the access to NOMIS. I would suggest trying to get access to NOMIS, and if you can't directly get it, make contact with, again, your lead at the prison and find out what's going on, because the NOMIS system has all the information in terms of the person's case. So any individual case that you're working with, they'll update when the release changes have been done. They'll update and they'll put, they'll entries in terms of having contact with the person, any changes or anything specific that you'll need to know about. Really, really, really important, because in terms of the changes from the 1st of September to the 1st of October, there would have been people being told they will be released on the 1st of September. Obviously now that's changed, and that can cause a big impact for people in prison. So it's really, really important that my suggestion is you check on NOMIS that this has been changed and that the person themselves have been told by their probation officer that their date has been changed to this new date. Because the last thing you want to do is third sector organizations being the ones having that conversation with the person and they're not aware that that date has been changed. This is why that multi-agency working with a probation officer and the prison officer manager is really, really important, so that we can find exactly what's going on. Does the person know, okay, great, now I'm going to go and see that person, we can go through that resettlement planning. So really, really important to kind of have that information to ensure that a smooth transition is in the community. And connection with other voluntary sector organizations within the prison. Again, if you make those connections, find out good practice, find out, it could be that you connected with another third sector organization. They will tell you, oh, did you know that this person was actually going now? Like, I found out from this way, or I found out this way of working when we worked through the gate really worked really well with these last minute releases. Really great to have that connection and collaborate with other third sector organizations, which is why, for example, attending those reducing reoffending meetings in the prison are really, really useful ways to kind of connect with other voluntary sector organizations who are going through the same issues that you'd be going through. And finally, in terms of the FTR 56 feedback, I know we just mentioned this about the fixed term recalls changes, and we found a lot of issues linked to a higher recall rate. Same with the SDS 40 and ECSL releases. There's been a higher recall rate on those types of releases. Something to bear in mind. Obviously, we want to decrease the number of recalls, and although this, there's issues in terms of pros and cons about those changes or those the national releases, it's really important that we can try and work together to ensure that we can work best with the prison, the people in prison, to ensure the resettlement needs are taken into consideration to reduce that chance of recall.
Everyone's managed to grab a cuppa, stretch their legs for a few minutes, because that was a lot of information that we've just given you. We're next going to talk about some of the information that you have been providing to us, and then what we're going to use for that. So I'm going to pass you over to my colleague Lisa, who will talk you through the next slide.
Hi, everyone. I'm the policy officer here at Clinks. I'm really happy to see so many of you be able to join us today. And I'll be speaking to you, as Natalie mentioned, a little bit about what the sector has told us so far about the Sentencing Act and what they've seen. So as many of you may know, through the remit of a special interest group under the Reducing Reoffending Third Sector Advisory Group, or R3 as it's more commonly known, we've been engaging with the sector on the implementation of the Sentencing Act with the goal of ultimately developing an output that provides the Ministry of Justice and HMPPS with practical recommendations designed to support the greater number of people now going into the community and needing support. So as a part of our engagement for this special interest group, we held a series of specific sessions that covered things like the role of lived experience, drug and alcohol provision at the Collective Voice Forum, families at our latest Families Network session, and a final broader session covering resettlement, at which we heard from voluntary sector organizations working within each of these specific areas. And what we found from each of our discussions there was, in a little bit of a whistle-stop tour, as Sam mentioned earlier, is that first and foremost, resettlement starts with housing, but that housing in and of itself is not enough. So safe, stable accommodation was identified as the ultimate crux of successful resettlement across all of our sessions, and that housing instability really contributes to things like poor health outcomes, reduced engagement with services, unemployment, and ultimately an increased risk of recall. However, as we saw, that effective resettlement ultimately requires coordinated support across housing, health, benefits, employment, family relationships, and community networks. The second thing that we found was that continuity and early planning are absolutely critical, as I'm sure many of you know. So release planning should begin well before release and then continue seamlessly into the community. And late release information, things like poor communication and fragmented systems often fundamentally undermine the level of support and the quality of support that was able to be delivered by us. And the first 24 to 48 hours really were the most important and require the most intensive and coordinated support. And we also found that relationships often matter just as much as services in and of themselves do. So trusted long-term relationships were repeatedly flagged as a key factor in successful resettlement. And there's been an abundance of evidence shared with us to demonstrate that people like peer mentors, lived experience workers, and voluntary sectors of themselves engage people far more effectively than traditional services alone. And that support should be person-centered ultimately and trauma-informed and focused on building stability rather than enforcing compliance. Fourth, we found that community services needed greater investment ahead of Sentencing Act reforms. So the participants specifically expressed concern that many of the reforms may increase the number of people supervised in the community without specific and sufficient investment in local support. So VCSE organizations are central to delivery, but require, as many of you can understand, sustainable funding, early involvement, and equal partnership with statutory agencies. So existing communication and procurement arrangements can also create barriers for smaller specialist organizations in particular. And ultimately, on this point, without this adequate investment in the voluntary sector to match the level of increased demand for services, organizations are more or less being set up to fail. And as a result, there's a very high risk of shifting what was originally a crisis in the prison system to a crisis in the community. And even though the role, as Sam mentioned earlier, the role in the funding of the voluntary sector was one of the key arguments made by David Gauck within the independent sentencing review and has been accepted by the government, we have yet to see an adequate uplift in funding and resourcing available for the sector. The fifth point on the slide there is that current systems often prioritize enforcement over support. So breach and recall processes can respond to relapse, housing instability, mental health difficulties, or missed appointments with enforcement rather than support, which is very, very harmful to the people that need the support most. They end up not receiving the level of support and the quality of support that they really need. And participants in our sessions had called for more problem-solving approaches that address the underlying causes and preventing avoidable recalls. And recall was widely viewed as a sign that support systems may have failed, not just being a compliance issue. Sixth, we found that one-size-fits-all approaches ultimately do not work, and that there's specific groups that require functional, tailored support, including women, young adults and care experienced people, older people leaving long sentences, neurodivergent people, people with disabilities, people with mental health, substance misuse, or chronic health needs, and that services for these people should be accessible, inclusive, and responsive to every differing need that is available. Seventh, families and communities are very, very, very important and quite essential to successful resettlement. So families, children, peers, employers, faith groups, community organizations all play a very critical role in the rehabilitation process, and that family services are often entirely underfunded despite their importance in supporting well-being, stability, and compliance. And reforms that we found from our discussions, reforms should consider impacts on families and family support organizations from the outset. Last but not least, we found that stronger accountability and partnership work are really, really essential. So participants in our roundtables had highlighted that fragmented responsibilities across justice, housing, health, and local government, and that it was found to be quite problematic in that services felt a bit disjointed. The lack of communication made it so that organizations didn't necessarily know what was going on. There were information delays, so on and so forth, and that clear accountability is needed for outcomes such as homelessness, failed referrals, and breakdowns in continuity of care, and that national minimum standards, better information sharing, and stronger cross-sector leadership were identified as priorities. And the overall message that we found in all of our sessions was that the successful implementation of the Sentencing Act depends not only on the legislative changes that have been announced and made, but on the investment in housing, community services, continuity of care, family support, and voluntary sector partnerships. Without these foundations, things like the risk of homelessness, disengagement, and recall remain very high. However, with them, the reforms actually present an opportunity to improve rehabilitation and reduce reoffending. And with that being said, I shall now hand you back to Natalie.
Thanks, Lisa. That was no mean feat, actually, summarising what was pulled out of all of those sessions, because there was a lot of information given to us by the sector. So, yeah, you're doing really well. So how we're using your information, as Lisa's mentioned, we have the Reduce and Reoffend in Third Sector Partnership. We created a special interest group. We call them the SIG. We love a good acronym in criminal justice. So we've been gathering the sector's views, taking them directly to ministers, and we will continue to do that. So any questions, any changes, anything that come forward, we ensure we gather that together and we make sure that there is a commitment to the voluntary sector playing that crucial role in terms of the Sentencing Act. We're currently in the process of developing a Clinks manifesto. For anyone who's kind of been involved in Clinks work for some time, you'll remember we've done the Clinks Think, so it's kind of building on that, really setting out clear policy challenges and direction for the sector. We work really closely with the Third Sector Partnership team within HMPPS, and we've been developing a non-funded partnership agreement with them. We brought together the sector to identify what could be done to improve collaboration between prisons and probation and the sector at a kind of local level. And then this is when sectors receive funding from external partners. And so these documents are currently sitting with legal, going through legal processes at the moment. But the aim is that each local area will adopt a similar approach. So if we have this document, we'd have one for prisons, one for probation, making it easier for the sector to navigate. And so there would be some confidence and reassurances that it's been through the legal process and everything is kind of where there's maybe a little bit of jargon, we can explain it and simplify that process for the sector. The area engagement team are working really closely with the HMPPS in the different areas. We're understanding their priorities and we're trying to improve relationships with the sector. So, for example, in the North East Yorkshire and Humber area, I've been developing a voluntary sector strategic planning meeting between Clinks and officials, and that's really starting those conversations. It's early days, but developing kind of terms of reference. What is it we're trying to achieve? How are we going to get there? And really trying to collaborate and set expectations, because ultimately everyone wants the same goal of supporting people in the criminal justice system. And so with the intention that we will try and replicate that across all areas. And so in the majority of areas, the introduction of an area engagement officer is new. So we've been fortunate to bring in some new posts this year. And so they've been spending the first few months carrying out mapping and understanding who's delivering what in the areas. And then this information's all been pulled together in a new directory of services, which we're hoping to launch by the end of August. And the directory should be used as a tool for any frontline staff in all sectors. So you'll be able to search for different probation areas, different themes, different geographies, different issues to better understand what's happening in the sector and how we can collaborate. And so we kind of, like I say, constantly using the information. We have that opportunity I mentioned earlier. If you've got questions, you've got comments, you've got thoughts, do email us at the support at inbox or the policy at inbox. And we've also got criminal justice forums coming up in September, October, where you'll be able to kind of have those area-based discussions of those challenges and queries. So now we've got time for yourselves to ask lots of questions, and Sam is going to take the hot seat to try and answer the questions. But we will, like I say, we're not going to record this session. We are going to take note of all questions,